Hi, so we're back here again with another video. This video is going to go into our assault and battery playlist. This video is going to deal solely with battery, just like how the other video dealt solely with assault. Sorry if my voice sounds a little off. I am a little under the weather today, but really wanted to put out this video, so let's get into it. Obviously, don't forget to subscribe, like, share with your friends, leave comments for us down below because, hey, we want to know, we want to hear from you guys. We want to know what kind of videos you would like to see, what areas you would like us to cover. All right, so let's get into it. Battery connotes an intentional act on the defendant's part. The force applied to P may be in any form. So, for example, it could be throwing water on the plaintiff, spitting on the plaintiff, pulling their hair, pulling a chair from under them, right? There is no need for an injury to result. So, there is absolute no need for the plaintiff to have been injured. The force just needed to have been applied, right? In the case of Cole versus Turner, Chief Justice Holt stated that the least touching of another in anger is a battery. Whether or not the defendant must be angry is quite a controversial point. Generally, it is thought that there is no need for anger in the sense of aggression. It is accepted, for instance, that an unwanted kiss may be battery. The essence of the tort appears to be that the plaintiff does not consent to the use of force or the infringement of his or her physical integrity. Thus, while everyone is taken to consent to being touched in a crowd or to contact generally acceptable in the conduct of daily life, for example, the tap on the shoulder in order to attract attention, there would not generally be implied consent to rough pushing or practical jokes involving the use of force. Things got a little interesting though, because the UK Court of Appeal held that in order to constitute a battery, a touching had to be hostile. In Wilson versus Pringle, the plaintiff and the defendant were of the same age and attended school together. The defendant, as an act of horseplay, pulled the plaintiff's bag off of his shoulder. This caused the plaintiff to fall and injure his hip. The trial judge was of the view that this was a clear case of battery. The defendant appealed. It was held this was not an automatic case of battery. Lord Justice Coombe Johnson said, another ingredient in the tort of trespass to the person is that of hostility. If there is hostile intent, that will by itself be cognate evidence of hostility. But the hostility may be demonstrated in other ways. Hostility cannot be equated with ill will or malev- malevolence. Y'all know the word I'm trying to pronounce. Don't laugh at me. It cannot be governed by the obvious intention shown in acts like punching, stabbing, or shooting. It must be a question of fact. Later, in the case of Re-F, Lord Justice Goff queried the need for the element of hostility. The better view would seem to be that the element of hostility will be present where there is no consent, expressed or implied, to the infliction of force. In other words, hostile describes not so much the attitude of the defendant, but rather relates to the physical inviolability of the plaintiff. Conduct will be hostile then if it can reasonably be taken to be unwelcomed by the plaintiff without lawful excuse or generally acceptable in the conduct of daily life. It's important for you to note the case of R versus Ireland because in that case it was stated that even silence which causes psychiatric damage may amount to a battery. So in R versus Ireland, the defendant made repeated silent telephone calls, mostly at night, to three women, as a result of which they suffered psychiatric illness. He was charged with 3 counts of assault occasioning actual bodily harm. The House of Lords held one. Sorry, one was not that important. The House of Lords held the making of silent telephone calls which caused psychiatric injury to the victim was capable of amounting to an assault, where the calls caused the victim to apprehend an immediate application of force. Accordingly, the the appeal would be dismissed. Okay, so that is pretty much it for battery. It was very short, very nice. If you have any questions, if there's anything that you do not understand regarding battery, just leave us a comment down below. And yeah, you can also feel free to add us on Instagram. What we do on Instagram is that we do a lot of little snippets where we do definitions and stuff like that. We post for you guys in order to help you with your studies. So you can feel free to add us on Instagram at Law Nerds Tutoring. Thanks so much for coming out for another video. Please stay tuned for the next video. Our next video is going to be on the defenses to assault and battery. That's also going to be really short and really sweet. Once we get through the defenses to assault and battery, we are going to go on to trespass to the person. And all of these videos obviously will be included in our assault and battery folder on YouTube.